Good morning, Your Honors. My name is Andrew McBride from the law firm of Wiley Ryan, and I represent CTIA, the Wireless Association. That the government is forcing a private party to speak. This is not a case about the government's speech, and nobody debates that the city of San Francisco can speak in its own voice. You know, my members are selling cell phones and then the service that goes with the cell phones. And they want to say during this transaction, as the person heads out the door, you know, enjoy your new phone and use its many features and use it as much as you want. And the city of San Francisco makes them say, hey, wait a minute, this device might cause cancer. You know, to call this a fact sheet, you know, is almost laughable. It's like calling the Communist Manifesto a treatise on economics.
Well, you're saying it's misleading, correct? I mean,
well,
even
both
though
that it's
some are misleading,
that it's an opinion,
or have basically the parties told us
I don't
that
think so, Your
Zador is where this is.
I think the court could hypothetically, but it tried to edit. It
eliminated its effort was to eliminate what was misleading.
We don't think it got there.
So he's saying we've eliminated the misleading elements, and you disagree with that, but that's a factual statement of the district court, to which we must give some deference.
Let me say, first of all, Judge Schroeder, if I could, I never got a crack at that document. In other words, that's not a finding of fact, because the judge amended the document, and I never got a chance to show that it remained misleading. He sort of invested himself a little bit in the case. Where's the evidence I can put in front of this court? I can't have expert declarations on, I can't have a survey on what this actually, the effect on consumers. I can't have scientists.
Well, we have about 50 amicus briefs here.
Well, but
do any of them contain anything that you want to rely on?
Good morning. My name is Vince Chabria. I'm with the San Francisco City Attorney's Office. Let me start, though, with this whole argument about I didn't get a crack at this new fact sheet. I didn't get a crack at these statements. In the district court, we had the original fact sheet, and CTIA was the one that argued that these particular statements are misleading.
And it is a little unusual that, you know, I don't fault the district judge in the sense that, you know, many times, but the district judge essentially told you, if you do this, your ordinance will pass constitutional muster. So you had a little free judicial opinion, and then you get to come back, and then, you know, voila, it passed judicial muster, and they're saying, well, then I don't get to address this whole thing in its recomposed form.
There is no rule that says that the government must wait until we know that a product actually kills people, that we have conclusive proof.
Well, you don't have to wait to speak, but what do you have to do before you can make someone else speak?
We don't have to wait until we can make somebody else speak, because I mean, just look at asbestos, look at tobacco. I mean, there was a long time where we didn't have conclusive proof that tobacco kills people, that asbestos kills people, but there was a strong suspicion. And
that under as the WHO defines the term, coffee and pickled vegetables are included in the group of possible carcinogens. Once people see carcinogen, they're going to say, oh my God.
Well, I'm glad that you brought up coffee, Judge Korman, because, you know, anybody in California who walks into a Starbucks knows that there is a very strong warning in Starbucks about coffee. And I
never noticed it, I have to say.
I was there this morning too, so tell me what it says.
I'll look for it next time.
And it says warning in big bold letters, and it says this product contains acrylamide, which is known by the state of California to cause cancer. There are numerous laws all over the state of California, all over the United States, excuse me, worker health and safety laws that require the disclosure based not on causation, but a correlation found by scientific bodies like the World Health Organization, and they are saying that you can't do that. You have to wait until we can actually identify somebody who has died. And there's a
you're getting carried away. Why don't you just ban it? Is San Francisco going to wait till people start dying before they ban the sale of it?
You know, our Supreme Court, which is obviously we listen to, is really quite robust on the First Amendment. And so I think that the jurisprudence of the Supreme Court doesn't really favor that you can compel them to say these things. Let's assume this case is going to go to the U.S. Supreme Court, and maybe it will. Tell me how you're going to get upheld there.